Right, thank you, Professor Jacobs. My thesis is called Who Pays for Road Violence? Rethinking Roads, Cycling, and Tort Law. First of all, I'd like to share the acknowledgments that Professor Jacobs made. And also thank Dean Waters for all the help during all this process, and Professor Smith and Professor Derek for accepting being in my committee. And also a quick information, during this process I've been through some mental health issues, and I encourage all my friends who are going through the same issues to go to Student Counseling Center. That's their website, and it's in room 293 of the CAW Center. All right, so my thesis is divided in three main topics. First, who socially belongs to the road, who legally belongs to the road, impacts to road peace. I'll explain better the following slides. Just a parenthesis that the scope of my thesis is on tort and insurance law. So I'm not dealing with criminal law, administrative, and urban planning. And also I deal with automobiles and bicycles when they collide. I'm not dealing with collisions involving automobiles and automobiles, or cyclists and cyclists, or pedestrians and cyclists. And it's also focused on Ontario law because I needed to have a focus on the thesis. So first, who socially belongs to the road? So we have some very good literature in history and sociology on means of transportation in the city. So we know that the bicycle came before the automobile, of course. It was considered to be the first freedom machine. And the cyclists were leading the good roads movement. So the first good quality roads that we had in the cities, they were due to this movement that was led by cyclists. And ironically, it allowed automobiles to travel faster in the cities. And then the automobile came, and the topic of my thesis came, that is road violence. So in this graphic, you can see that the amount of road deaths were almost zero in 1907 when we had few cars in the streets. And in 1923, that's in the United States, it is almost 16,000 road deaths per year. So this coincided with the advent of the automobile. So the advent of road violence comes with the advent of the automobile. First, when the automobile came, and we had a lot of road deaths, the blame of those deaths was obviously on the driver and on the car. If they're putting this dangerous vehicle and they're killing people, they are to blame for all those deaths, right? So you could see some newspaper like this cover of New York Times saying nation roused against motor killings, and it pictures a car and a driver. The driver is the death itself, killing people. But this idea changed over time because a concerted movement by the automobile industry that invested in changing the idea of blame of road deaths. So they had some campaigns like the jaywalking campaign that would place the blame of those deaths in other factors as in the pedestrian. So they started saying, that's the way the pedestrian's crossing, that's not right, that's why they're dying, right? Or that's because the driver was not careful enough. It's not about the car, it's about how you drive, it's about how you cross the street, it's about how you behave in the streets. So they were successful in changing our perception of blame for road deaths. We don't blame the cars anymore for those deaths. We are always blaming other factors. And that's the result of this success. We have now 1.2 million road deaths per year in all world. Here in Canada, 2,000 road deaths per year. And that's when it comes. The rebirth of the bicycle, so we forgot about the bicycles in favor of the automobile, and from the 1970s on, we're having some advocates claiming that bicycles are a good means of transportation. So they claim that bicycles are a solution for health, because people exercise more, it's a solution for traffic jams, it doesn't occupy a lot of space in the streets, it's a solution for road violence, it's not heavy and fast as cars. And of course, the old ways of thinking are still present. we had the ex-mayor of Toronto, the brother of Bill Ford, the ex-mayor Rob Ford, that said that cyclist deaths are their own fault anyways. So then we come to law. I came here to research cycling law. So cycling law started as the law of wheelmen. Before the automobiles, legal scholars would study the law related to cyclists, and they would call it law of wheelmen. But then the cars came, and the cars came and brought a lot of problems to law, and law started to focus on the automobile. So that's what I call the motorization of laws. So we have traffic laws, road laws that are all focused on to solve the problems that the cars brought to the cities. And then, with the rebirth of bicycle came the rebirth of cycling law, which is the reason that I'm here in Windsor, because I found the article by Professor Chris Waters with this name, the rebirth of cycling law. My focus in this thesis is specifically on tort law. So I'm going to show you 3 topics on tort law that deals with cyclists and collisions with automobiles that show that tort law on cycling has been pretty confusing here in Canada. So first, the topic of reverse onus of proof. So the general rule in tort law is that if you claim that somebody else was negligent, you have to prove that this person was negligent. The reverse onus of proof that we have here in Ontario says that if you claim that somebody else was negligent, the driver will have to prove that he or she was not negligent, right? So one of the results of this is the case of Policia versus Ontario that said that right-of-way is not enough to prove absence of negligence. So I'll explain. The driver hit a cyclist in the intersection, and the driver had the right-of-way. So the driver said to the court, hey, I had the right-of-way, I was not negligent. The court said, no, having the right-of-way does not prove that you were not negligent. In British Columbia, they do not have this rule of the reverse onus of proof. So the cyclists have to prove that the driver was negligent. And in McIntyre versus VP, almost similar situation happened. A car hit a cyclist, but the cyclist had the right-of-way. And the cyclist went to the court and said, hey, I had the right-of-way, so the driver did not respect my right-of-way, they were negligent, right? And the court said, no, having the right-of-way is not enough to prove that the driver was negligent. So it's sort of the same situation, but in reverse. And it proves that proving negligence or proving that you don't have negligence is very difficult when it comes to traffic collisions. Another absurd situation happens in the topic of cyclists passing on the right? So according to road laws in Canada, you have to ride your bicycle on the right? So sometimes we have paved shoulders where cyclists ride. In this situation, there was a paved shoulder, and there was the traffic lane. There was a van in the traffic lane, and the cyclist was passing on the paved shoulder. They were on the right, obviously, the shoulder's on the right, and they were passing the van. The van crossed the fog line. They did not hit the cyclist, but the cyclist lost their balance and fell. So the cyclist went to the court and said, hey, this driver crossed the fog line and made me fall, so they were negligent. And the court said, no, they were not negligent. Crossing the fog line is not enough to prove negligence. Plus, you were wrong because you were passing the van on the right, which makes no sense. Like, they did not explain what the cyclist should do, like stop behind the van that was on the left side or go to the traffic lane to pass on the left side. They did not explain. Another topic is on cyclist helmets. Research shows that helmets are 17 times more effective for automobile occupants. Here in Ontario, helmets are not mandatory for adult cyclists. Nevertheless, in Evans versus Toronto, it was decided that a cyclist not wearing a helmet is contributory negligence. So I've read the cases, and none of them really explain why they're saying that the cyclist should be wearing a helmet or should be contributory negligence, should be considered contributory negligence. No case law has determined contributory negligence of pedestrians or car occupants for not wearing helmets. So it's more effective for drivers or for car occupants. There is no evidence that it's more effective for adult cyclists. But just because the court said, nah, I think you should be wearing a helmet, with no research on this, with no explanation at all, they said, nah, you should pay for part of your own damage because you should be wearing a helmet. And it's not even law. It's not even mandatory. So now I'll show some alternative to the negligence system that we have in common law and in Ontario. So options on tort law. We have the negligence system, which is the system in which we have to claim that the other part was negligent so that we can receive compensation. So if the other part was not negligent, you have to pay for your own damages. We have the strict liability system that does not discuss fault. So it's usually put into situations that you impose risk to others. So if they consider that driving is dangerous, they'll say that if you hit someone, you're going to pay, no matter who's at fault. You have to pay attention so that nobody will be hurt because of your risky activity. We also have the no liability system, which is a system that does not discuss liability, does not discuss tort. It's replaced by another system. In this situation, we're going to talk about the insurance system replacing the tort system. So nobody's going to even discuss tort or liability law. We'll go directly to insurance law. So the situation of France and Germany is that they use the strict liability system. So they use the principle of the risk of the operation of the machine. They consider driving a dangerous activity, and they want you to pay attention so that nobody will be hurt due to your activity of driving a car or a van or an automobile. Either the car or the keeper of an automobile are strictly liable. In France, both the driver and the registered keeper of the automobile are liable. And in Germany, only the keeper is strictly liable. So if you have a car, you have to pay attention so that you don't lend the car to your son and he kill someone, because you're going to be liable. So whoever you lend your car to, you're going to be strictly liable for their damage that they cause to other people. And in both countries, third-party liability insurance is mandatory. So that's very important because perhaps the driver or the owner of the automobile will not have enough money to cover the damage of the victim, but you can be sure that they'll have a insurance because it's mandatory. So the insurance company will cover your costs. In Ontario, we have a no liability system that they call no fault. I call no liability because no fault, strictly liability is also a no fault system, so I think the terminology is not pretty accurate. They call no fault insurance, but it's only for first party damages. So what happens is, if you're driving a car, you hit your car, your insurance is going to pay for your damages without discussion of fault. If you hit another car, your insurance company is going to pay for your damages, and the other driver's insurance company is going to pay for their damages. Nobody's going to discuss fault, who's at fault, who's right, who's wrong, right? The benefits are set by the statutory accident benefits schedule, so they have all the situations that you can be involved in and the amount of money that you're going to receive. And it does not include third-party damages. So if you hit a cyclist, the cyclist is not going to receive automatic compensation. So as I said, if you hit another driver, the other driver is going to receive automatic compensation from the insurance company. But if you hit a cyclist or a pedestrian, they have to sue you. They have to go through tort law to prove that you're negligent, and then after the court decides that the driver is negligent, the victim will receive compensation if they receive compensation, because if the driver is proven not negligent, the victim will remain with no compensation at all. Beside us, we have Quebec. The no-fault insurance system of Quebec includes third-party damages. So it's a system created to protect road violence victims, and a victim is a person who suffers bodily injury. So they're concerned about protecting the person. That's why damages to property are left out. So if you have damages to property in a traffic collision, you're going to have to go through tort law and sue the driver who caused the damage. The system is administered by the Société de l'Assurance Automobile de Quebec, which has its income coming 75% from annual contribution of vehicle owners, 15% from the attainment of driver's licenses, and 10% from interests and taxes over gasoline. So you can see that those three sources of income of the Société are taxes or costs of automobile owners or drivers, right? So what we can conclude here is that the creators of road violence, drivers and car owners, are the ones who are paying for those damages. A problem that we have in this system is that if you're a driver and you hit someone, like there's no tort or insurance consequence for you. While in France and Germany, as you have to contract your own private insurance, your history of road violence is going to be on your file, and you have to pay more for premiums if they see that you have a history of violence, right? Not in Quebec. In Quebec, every driver will pay for all the damages, and if you hit someone, there's not going to be a raise in the premium because there's no premium. And then we go to the conclusions of my research, which is basically that Ontario could do better. First of all, the negligence system leaves some victims with no compensation or delayed compensation. So some people will not receive compensation because the court will say the driver was not negligent. Or some victims will receive compensation, but they'll have to go through court, and the driver will say that they're not negligent, and then only after that they're going to receive compensation. Road violence requires immediate attention, right? You're going to go to hospital, you're not going to be able to work, and that's one of the failures of the negligence system. Also, the negligence system is biased to a car-centered understanding of the road. So we saw some cases that the judges simply decided, no, the cyclist was wrong, but why? They couldn't explain. They didn't empathize with the cyclist, and that's something that you can expect by adjudicators who drive, right? Most of them drive instead of cycle, so they tend to empathize more with the situations that car drivers face. We also saw that strict liability system is successful in compensating every road violence victim, or at least almost every road violence victim, for their damages, because we don't need to discuss fault. And the no liability system, as we have in Quebec, is also successful. However, it does not affect the driver who commits violence. So remember that we're talking about insurance and tort law. We're not talking about criminal law and administrative law. So the driver might have points. The driver might get, convicted by a crime. That's not what I'm talking about. I'm talking about insurance. So in the insurance system or liability system that they don't have, there's no consequence for a driver who commits road violence. And then I finish with a quote by Lord Denning. I am persuaded that any civilized system of law should require, as a matter of principle, that the person who uses the dangerous instrument on the roads, dealing death and destruction all around, should be liable to make compensation to anyone who is killed or injured in consequence of the use of it. It's too bad that the Lord Denning's understanding was not included in the common law. He was not the majority opinion. That's it. Thank you.
So thank you, Celso. So for the next part, we'll be doing